This is Barry Zalma speaking for Claim School Incorporated's Zalma's Insurance Fraud Letter for November 15, 2022. This, the 26th year and issue 22 of the 26th year of Zalma's Insurance Fraud Letter. It will provide articles on the following subjects. First, a void policy may not respond to a claim. Douglas McKenzie and Jeffery Bigsby filed an insurance dispute against GEICO Marine Insurance Company in the Superior Court of Washington for Snohomish County on April 7, 2022. GMIC moved to dismiss the complaint, and in Douglas McKenzie versus GEICO, a November 2, 2022 decision of the United States District Court for the Western District of Washington, the United States District Court resolved the dispute and concluded that a person who is convicted of insurance fraud in the presentation of a claim must result a priori in the voidance of a policy of insurance. Schladetsky's fraud voided the policy. The plaintiffs, who could not collect from the felon, tried to collect from the insurance policy issued to the felon, although the court gave consideration to the plaintiffs' arguments. It had no choice but to grant GMIC's motion, since there was no policy to respond to their claims. They have a judgment against the person responsible for their losses, and they should spend their efforts to collect from him, not try to bludgeon an insurer who was already a victim of a fraud to increase the cost of fraud imposed on GMIC by the felon. You may read the entire article at my blog, which has a link to the PDF for the article. Next, you should read about the State Bar of California and Tom Girardi, because on November 3, 2022, the State Bar of California published an open letter after being criticized about their handling of Mr. Girardi's multi-million-dollar defalcations and absorption of his clients' money into his private accounts. For those of you who did not read earlier reports about Attorney Girardi, he was found to be without funds and was accused of using money belonging to his clients held in trust accounts for his personal use. As a result of the State Bar investigation, he was eventually disbarred. The State Bar was embarrassed by its lack of action and issued an open letter to explain its position. Everyone involved in the business of insurance should be aware of the contents of the announcement of this letter. The Chief Trial Counsel sought disbarment of Girardi in 2021. Following a default, Girardi was disbarred by the Supreme Court in June of 2022. Also in 2021, even before Girardi was disbarred, the State Bar's Client Security Fund began making payments to his victims on an accelerated basis. On behalf of the entire board, the chairman of the board of the State Bar of California stated that he wished to express his appreciation to all who have reached out with their thoughts, concerns, and complaints. "We hear you," he said, "loud and clear. Your experiences serve as a sober reminder of the importance of our efforts to do better. We are committed to doing so to fulfill our mission of protecting the public." Literally admitting he's closing the barn door after all the horses have escaped. You may also read the full article and his full letter of appreciation and concern at the newsletter with the link on this blog post. Double jeopardy eliminates 3 of 4 convictions in a case decided by the Court of Appeals of Colorado called the People versus Natasha Ernest Robinson, a decision dated October 27, 2022, where prosecutors admitted that they had overcharged a defendant, but still had the Court of Appeal agree that her conviction for insurance fraud must stand. Natasha Robinson appealed the judgment of conviction, entered on jury verdicts finding her guilty of 4 counts of insurance fraud and 1 count of false reporting to authorities. She contended, among other things, that because her 4 convictions for insurance fraud were based on a single insurance claim, those convictions are multiplicitous in violation of double jeopardy principles, and the court agreed. She should only be convicted of 1 count of insurance fraud. You can read all of the court's reasoning in the digest that is part of the November 15 issue of Zalma's insurance fraud letter. Next, you can read about good news from the Coalition Against Insurance Fraud that reported about 18 convictions for insurance fraud, including one where a pain doctor made more than $400,000 in false claims for steroid injections to Medicare and Medicare that were neither reasonable nor medically needed in the Pittsburgh area. Patients and employees said Dr. John Kyung Sang Lee required patients to get steroid injections even when plaintiffs said the jobs didn't help but rather caused more pain and other injuries. Lee also told employees to withhold his patients' meds if they objected to the injections. To justify billing insurers, Lee told staff to use templates, lying that his patients received 80% relief from prior pain injections. Lee pled federally guilty and is potential to serve up to 10 years in prison when he's sentenced in March of 2023. This full article can be read along with other criminal convictions at the newsletter Zalma on insurance fraud. Next, you can read about how to add to the professionalism of insurance personnel, where I provide effective training for employees in the business of insurance, whether in claims, underwriting, or sales. They're all hungry for education and training to improve their work in the industry. Next, there's an article about Florida's attempt to deter insurance fraud. On October 19, 2022, Florida Chief Financial Officer Jimmy Petronas held a press conference in Cape Coral to highlight fraud prevention efforts in the wake of Hurricane Ian. During the press conference, the CFO announced he will propose legislation including cracking down on bad public adjusters by curbing their ability to take advantage of Floridians under final duress, combating assignment of benefits abuse by eliminating the use of assignments of benefits altogether, creating a statewide prosecutor focused solely on property insurance fraud, probably the best of his suggestions, to hold fraudsters accountable to the full extent of the law, and lastly, requesting a $3 million anti-fraud public education campaign. You can read the full article at the link in the blog post. Then we have a listing of health insurance fraud convictions, starting with a home health manager who was sent to prison for $20 million Medicare fraud scheme. Felix Amos, 72, of Houston, Texas, pleaded guilty on December 18, 2018 to conspiracy to commit health care fraud. On October 31, 2022, U.S. District Judge Andrew S. Hainan ordered him to serve 30 months in federal prison and 3 years of supervised release, and he was further ordered to pay $21,197,440 in restitution. And on March 22, a jury returned guilty verdicts against Fausat Adekunle, 39, of Richmond, on 10 counts following a 4-day jury trial. Judge Hainan later ordered her to save 144 months in federal prison, to be immediately followed by 3 years of supervised release, and she must pay restitution of $21,197,440.14. You can read this article, including 14 more health insurance fraud convictions, in the full issue of Zalma's insurance fraud letter, which is available at the link. The next article dealt with other than health insurance fraud convictions, which included a former Seal Beach insurance agent who was sentenced for theft from an elderly consumer. Vincent Allen LaGrange, 66, of Seal Beach, California, a formerly licensed insurance agent, was sentenced in San Bernardino County Superior Court on 1 misdemeanor count of grand theft from an elder after an investigation by the Department of Insurance found he was acting as a licensed insurance agent to collect insurance premium payments from consumers, but pocketing the premium monies and leaving the consumers uninsured. LaGrange was sentenced to 1 year probation and has paid back full restitution to his victims. And that's probably why he's not in jail. The Department of Insurance revoked LaGrange's license and his entity license operating as LaGrange and Associates and Empire Valley Insurance Services in May of 2016 after proving he had overcharged an elderly consumer by collecting earthquake coverage twice and misleading her about the billing. LaGrange even financed her premium with a separate finance company without her knowledge and attempted to reapply for a new license 6 months later, but was denied. You may read this article in full, including 9 additional convictions, at the full text of Zalma's insurance fraud letter, which is available at the link on this blog. This video was adapted from my blog post and from the full Zalma's insurance fraud letter, which is available free to anyone who clicks on the link and the URL at zalma.com/blog. You can also view this video at rumble.com or youtube.com. And I'd appreciate it if you click on the like button at YouTube and the Rumble button at Rumble. If you found this video to be of interest and use to you and the members and friends and colleagues, please tell them about it and let them also subscribe to the newsletter, the blog, and the videos. And you might also wish to consider subscribing to my Locals channel and my Substack publications. Thank you for your attention.